Hi, Jenna.
Hello, Heather, and everybody attending.
Excellent. So, Jenna, you're an associate with DD West LLP. So, DD West provides a wide array of legal services and advice, but you specifically specialize in estate litigation and estate planning, correct?
That's right. 100% of my practice is dealing with estate matters and surrogate issues.
Perfect. All right. So, what I'm going to do is I am going to turn off my camera and turn off my microphone. I'm going to let you share your presentation. I will collect again everybody's questions, and when we get to the end of the presentation, I will come back and we will tackle everything.
Excellent.
Sound
Thank you,
good?
Heather.
You're welcome.
I'll share my screen now.
Okay.
Been practicing since 2013, which I can't believe is 12 years ago already. Time just seems to go by faster and faster, but I fell in love with the world of estates about 4 or 5 years ago now. And since then, my practice has slowly narrowed to including only estates. My practice is primarily estate litigation. I'd say probably about 65% is estate litigation, which means I go to court and help clients find resolution to kind of sticky issues that they might have. But then the rest of my practice deals with the administration. So that's drafting wills, that's preparing enduring powers of attorney, personal directives, as well as helping clients, executor clients, I should say, with probate applications and with administration applications, depending on if there is a will or there isn't a will in any given situation. I do also want to preface that this is my first ever online presentation. I've given quite a few in-person ones, but this is the first time that I'm doing this online, which might be a surprise considering my age, but my siblings have all told me on various occasions that I am an embarrassment to my generation when it comes to technology. So I'm glad I've managed to put together a PowerPoint and have shared my screen. We'll call that a win.
That's okay.
So
We appreciate you.
thank you, Heather. I appreciate you as well. So um, the PowerPoint itself is meant to just kind of be a bit of a guide, just so there's something visually up there. But if you haven't been able to tell already, I do love to talk. So what I plan to do is use the slides as something to help guide everybody and make sure you know what topic I'm discussing. But I'm hoping that once we get through these slides, we'll have lots of time left over for questions. Heather has informed me that a big difference between an online presentation versus in person is that there tend to be less questions, which is fine. I'm good just talking, but I do love when people participate and ask questions because I view this as, you know, a way to engage with the community and want to be able to provide as much assistance to you guys as I can. So with that being said, let's get started. So where there's a will, there's a way. That was the name I chose for my presentation. I thought it was a little bit tongue in cheek, but anyways. So first slide, what is an estate plan? And this might seem somewhat oversimplified, but I think it's important to discuss what exactly an estate plan is comprised of. So when we say an estate plan, we don't mean just the will. We are talking about generally 3 very specific documents. So that's your last will and testament, the enduring power of attorney, and the personal directive. And what's different about these 3 documents is that the will comes into effect when we've passed. The entire purpose of a will is to distribute assets and to determine certain administrative tasks that might need to be done when we have passed. An enduring power of attorney and a personal directive, on the other hand, are living documents, meaning they only come into effect while we are alive, but should we ever be in a situation where we've lost the capacity to make decisions for ourselves. So that's the difference, the primary difference, I should say, between a will versus an EPA and a PD. And then you'll notice that I also called it the last will and testament. So what that means is that during our lives, we may enter into multiple different iterations of our wills. We might redo our wills and then redo them again and then maybe again as things change and circumstances change in our lives. And so the last will and testament is a reference to the fact that in most jurisdictions in Canada, I can't speak for Quebec, but for every other jurisdiction in Canada, it is the most recent will that matters. So I could have prepared a will, leaving everything to my kids, and then 2 weeks later, make a brand new will where I leave everything to 2 of my 3 kids. leaving out the third for whatever reason. Maybe they made me mad or upset, or we had a falling out or whatnot. It's that will made 2 weeks later that matters. And the reason that's so important is because that's going to impact what your executor is able to do with probate when we've passed. It's the exact reason why probate is required and why banks and land titles are not going to release assets or transfer assets without seeing the probate, because there's no way of knowing if a beneficiary walking into a bank with a will has the last will and testament. So that's why it's called the last will, and that's why the knowing that it's the last will is so important. So that's what your estate plan is. It's the will, the power of attorney, and it's the personal directive. So the will itself, there's a few important considerations that go into preparing the will. The big ones are going to be an executor appointment. It's going to be the beneficiary selection, and then determining if you have any registered accounts, insurance policies, or pensions, because those are dealt with separately or differently, I should say, from other types of assets. And so just kind of talking about the executor appointment first. The executor is the person that you appoint whose job it is to determine what the debts are, if any other liabilities, make sure there's enough estate assets to pay out all of those liabilities, and then determine what the remaining assets are and how they're supposed to be divided. So those are the primary roles of the executor, but it's not just about assets. A lot of people make the mistake of thinking that a will only matters if you have a lot of stuff. That is not true. It's just one aspect of what making a will is. A much more important, or at least equally important asset of a will is you're laying out all of the administrative powers that an executor has. So it harkens back to what I was talking about in terms of going to a bank. Even if you have a bank that has a bank account with $10,000 in it, you might have a bank that's saying, nope, we're not going to release any of that to you until I see a will along with a grant of probate. And so it provides who is the person that is going to make that application for the grant of probate, who are the people that are supposed to receive the $10,000 sitting in my bank account. Then it also sets out if I have any sentimental items, if I have any personal items, if I have anything that I want a very specific person to receive, who ought to receive those things. If I was in a car accident shortly before I passed and I was in a piece of litigation, suing for negligence and wanting to get some compensation for that, who is going to be my litigation representative to continue that lawsuit and to then receive those funds on behalf of my estate. So there's a lot of things that go into a will. It's not just as simple or as clear cut as who gets my stuff. And I think that's what most of us think about when we think about what a will is, understandably, but it is a little more comprehensive than that. So when appointing an executor, I always tell clients that there are 3 factors that are important in determining who you ought to appoint. And so big one is location. I have a lot of people who have families scattered all about. And the way that most provinces are structured is because wills are provincially legislated, every single province in Canada and territory has its own piece of wills legislation. So wills are different in each province. And so because of that, it is highly recommended that your executor be somebody within the jurisdiction of Alberta. And then from a practical point of view, in terms of just being able to administer the estate, go to banks, hire accountants and lawyers or whatever professionals they might need, it is helpful to be in Calgary if you are resident in Calgary, but obviously resident of whichever city or province that you happen to be in today. But I myself am in Calgary, which is why I'm speaking from that perspective. So that's the first one, is location. Second one is age. And this again is a more practical consideration. So it just makes sense to appoint somebody younger than you. I would say the vast majority of my clients, if they have kids, are appointing their adult child to this role. So that's a big thing to consider if you don't have kids of your own. If there's a niece or a nephew, that's often a good idea as well. And then finally, relationship. And this just means trust, right? As we were talking about, this is a pretty big role and a very important role. And so you want to make sure it's somebody that you trust to do it and to do it well. But on top of that, somebody who's not going to feel overwhelmed or stressed or anxious about the role. Somebody who you think is going to be able to handle that type of a responsibility. So I would say those are the three big considerations in appointing an executor. There is also the possibility of appointing a professional body as an executor. There's banks and trust companies who will agree to act. I don't personally like recommending a bank or a trust company just because I find the fees they choose for doing so to be a bit inordinate. That's just my take on it. But there are certain professionals and organizations that will do it. Lawyers generally don't. I don't know any lawyers personally that would agree to be appointed as an executor, unless it's in a very specific instance for litigation. But just at the outset, I don't know too many lawyers who offer that as a professional service. So that's the executor appointment. The other thing to consider when putting a will together is the beneficiary selection. And so this is, of course, as I just said, wills aren't all about where you leave everything, but that is a big part of what doing a will is where would you like your assets to end up? And so the important thing to recognize here, there's two types of beneficiaries. There's what's called a specific beneficiary, and then there's a residual beneficiary. And so what specific beneficiary means is kind of what it sounds like. If there's a specific sum of money or a specific valuable item that you want to provide to a very specific person, you need to set that out in the will. So for example, if I want to make sure that my sister gets $20,000, then I would set out $20,000 to my sister. And so that's called a specific bequest. And then after that, my will would go on to set out who my residual beneficiaries are going to be. And so the residue, you can kind of guess maybe by what it's called, is everything left over. So you might remember I said the first thing the executor is doing is, are there any debts and liabilities? Are there any fees that the estate needs to pay, funeral expenses, all these sorts of things? So once all that stuff's taken care of, you have the residue, right? And so before you can pay the residue out, you have to look at whether there's any specific beneficiaries, and if they are, they get paid out first. And so then the residue is what's left after that. So after the debts and liabilities, the expenses, the specific beneficiary bequests, you get left with the residue. And so the residue goes to whoever you want to receive, usually the bulk of your assets. So to kind of use that example I was using, let's say that I had a will and I passed, my executor pays my funeral expenses. Maybe I have a mortgage that needs to be paid out. The house is sold, the mortgage is paid off. $20,000 goes to my sister, and then my residual beneficiaries is equally between my three kids. So that's how that would be structured, right? I've got all the debts being paid off, all the expenses being taken care of, the $20,000 going to my sister, then everything left over going to my hypothetical three children. So that's kind of how that would be structured. Which brings us to a different type of account, or a different type of asset, I should say, which is registered accounts, as well as insurance policies and sometimes even pensions. And so why I want to talk about these types of assets is because they're treated quite differently from the rest of our assets, like our house, our checkings accounts, savings accounts, vehicles, all those sorts of things. So a registered account would include things like an RRSP, a RIF, a TFSA, insurance policies. Of course, the most common one is the life insurance policy. So when we're talking about those sorts of things, and if you have those sorts of assets, you might be familiar with when you open up these vehicles with a bank or with an institution, generally they're going to ask you who you'd like to be the designated beneficiary. And so that's important because unlike the assets in a will, these assets will be paid out directly to whoever you selected as that designated beneficiary. And it's very important that you know who that person or people is or are, because it might not be who you want to receive those funds. Oftentimes we've opened these accounts decades ago and we, didn't have kids at the time, and maybe we appointed a sibling or a niece or a nephew or a friend, but now we would want that to go to a very different place. And so it's very important that you make these inquiries and you determine, okay, who are my designated beneficiaries? The way that you do that is you would go and talk to the bank or the institution where you have these types of accounts and just ask, and then they will let you know. And then in the will, there's two ways of dealing with these registered accounts. So we can either one, say it should, these assets should be paid out to whoever is named as a designated beneficiary on the accounts, or two, despite the fact that they have a designated beneficiary, it is my intention that everything flows through my estate, and so it would go to the residual beneficiaries. So those are the two ways of dealing with it. It is my professional opinion and my personal experience, and I tell all clients that even if we are saying everything goes through the estate, we do want the designated beneficiaries to match the residual beneficiaries in the will, because otherwise you might have a bit of a clawback problem where all of the funds are meant to go to your residual beneficiaries, but the bank has already released your entire RIF to the designated beneficiary who's a different person. And so now these residual beneficiaries are in the position of having to try to get those funds back, which of course can lead to litigation, which most people are trying to avoid in their estate planning. So those are the important considerations in a will. We'll move on to talking about the role of the executor, which I've already briefly touched on. And a big thing that I really want to point out here to people, because I get this all the time when talking to people about will planning, is they have more than one child and they can't possibly bear the thought of only appointing one or two and leaving one or more of their children out. But I like to tell people being an executor is a job, is not a gift. Whichever kid gave you the most trouble as a teenager, appoint them. This is your way to get back at them. It's a lot of work, and you want to appoint somebody who you think is going to be able to handle the work. You have to remember that generally speaking, unless you're using a professional executor and you're appointing somebody who's close to you and is probably grieving the fact that you're no longer here. And so when we're grieving, we're not necessarily, clear-headed or making the best decisions, and we're not necessarily acting the way that we normally act. And so it is important to put some thought into who of my kids, if any, is in the best position, both in terms of their personal life, their personalities, and their professional lives, to take on the role of being a trustee of my estate, of being able to go to the banks, to go to land titles, to box up the house, to put the house up for sale, to determine if there's registered accounts, to deal with all that kind of bureaucracy that we're forced to deal with as executors. And so it's a good idea to remember that you are giving somebody a lot of work, and this isn't, necessarily an appointment of honor, which I think we tend to think of it as. I know that my own parents think of it that way, and I do myself to a large extent. It is, it is very much a compliment to be selected as the executor and to know that your parents have that faith or belief in you, but it's also something that very practically you need to have a skill set to do. So I think that's something that's important. You can appoint joint executors. There's nothing wrong with doing that. Generally speaking, when I have executor clients and there's two, one usually does renounce to allow just one to go forward, just simply for the practical reason of it's easier for one person to deal with it. However, I also very commonly work with joint executors where one does not want to renounce, and there's no problem with doing that at all. Again, just those three considerations from the last slide should be kept in mind, where you want somebody in Alberta, ideally, younger than you, and again, who you trust and who you think is capable of doing the role. And so if you're going to appoint two executors, it's definitely nice if you think they'll be able to get along and work together. So that's what I would say in terms of the appointment. Moving on a little bit to what the executors will be doing. We've touched on, the primary role of the executor, which is to determine the debts of the estate, if any, pay them off, determine the assets, and then distribute the assets. But another big role that the executor has to do is apply for probate. So probate, if you're not familiar, is a process where you take a last will and testament, you submit it to the Court of King's Bench of Alberta. If you're in Alberta, if you're in BC or Ontario, obviously it would be to the same court there. You submit the will to the Court of King's Bench of Alberta, along with a bunch of paperwork that comprises your probate application. swearing under oath that you have looked around as executor and believe that the will you are submitting to the court is the last will and testament, and that no other will was done afterwards. And so what this is doing is it's allowing a judge to review all of that paperwork and to make a decision that, yes, I do in fact believe this to be the last will and testament, and so I'm going to grant this will into probate. When you have that grant of probate, you can take the grant along with the will, go down to the bank, go down to land titles, and then you'll be able to say, here you go. You don't need to be concerned about any liability banks. You don't need to be concerned about any liability land titles. You are releasing these assets to the intended and the correct beneficiaries. Because if you don't have that grant of probate, like I said earlier, the banks will not release funds because they're worried about getting sued. They're worried about their own liability if they release assets to the wrong beneficiary when there's a will done 2 weeks later, naming completely different individuals, right? So that's what the grant of probate is for, and that's why it's so important. And then again, I always get this question when I'm talking about probate, so I'm going to kind of jump in and see if I can head it off right now. But a lot of people ask me, Jenna, how do I avoid probate? Because a lot of people don't want to do it. And I always say in Alberta, it's not really a big concern. If you're in British Columbia or Ontario, yes, you want to consider estate planning steps to avoid probate if possible. But in Alberta, it's not a huge concern. We don't have a percentage of property being paid as a probate fee in this province. It's a nominal fee. So I think the course right now is a maximum of $500, maybe $600 in terms of what the probate fee, in terms of what you're paying to the government as a probate fee. Whereas in Ontario and BC, that can be different. So those are kind of the big things. The other thing, of course, that an executor is doing is if you haven't provided specific instructions ahead of time, they would be responsible for getting the death certificates, applying for any death benefits, and making sure that the celebration of life or funeral arrangements have been made and are being paid for from the estate. All right, so this slide was supposed to be my checklist of where we're at so far. So we've talked about what the will is. So why don't we move on and talk about what the power of attorney and the personal directive are. And so if you remember from just a few minutes ago, the will is a document that comes into effect when we have passed. The power of attorney, the personal directive, these are living documents that only have impact while we are alive, and for the most part, only come into effect when we have lost capacity to make decisions for ourselves. So what that usually looks like is a stroke, dementia, Alzheimer's, a physical, kind of mobility issue, those sorts of things. So that's what these documents are for, is appointing somebody to help out with financial decisions and appointing somebody to help out with healthcare and personal decisions. So the enduring power of attorney, you would appoint an attorney to deal with any of the financial decisions. So that means monitoring investments, paying professionals. If you are living in any sort of home, making sure that the home's rent is paid each month, making sure you have necessary money to pay for food and other needs. It's paying the mortgage and any other regular bills that need to get paid. It's managing the finances. So anything you're currently doing with your finances, this person would have the authority and access to do. The personal directive, on the other hand, is when you appoint somebody to look after all of your medical and personal decisions. So usually what this looks like is somebody taking you to doctor's appointments, giving instructions to doctors and other healthcare providers, looking out for your well-being, making sure that the next door neighbor's not trying to scam you and those sorts of things. So that's what your personal directive is. So I always say they're kind of meant to govern the two spheres of our lives. The enduring power of attorney governs our professional financial life, and the personal directive is meant to govern our personal and healthcare life. So that's what those documents are doing. The three together, the will, the power of attorney, and the personal directive, together is an estate plan. So those three documents are your estate plan. They're very important to have. Especially with the power of attorney and the personal directive, because there is no legislation that governs who would be your attorney for your agent, which is the power of attorney personal directive, that's what they're called, if you don't have them. And so what that means is you have to pay somebody like me a lot of money to go to court and make an application to be appointed as either a guardian or a trustee or both for your loved one who has lost capacity. So what I mean by that is you could go and get these documents done for a few $100s, the enduring power of attorney and a personal directive. And then if you're ever in a situation where you've lost that capacity to make decisions, whoever you've appointed will just have to waive that paper at the appropriate authority, and then they can do what they need to do to take care of you. But if you did not get these documents done before losing capacity, you cannot enter them, because to enter any legal document requires that you have capacity. And so if you've lost it, you can't then execute an enduring power of attorney or a personal directive or a will for that matter. And so what happens is, if you need somebody to manage those things for you because you've lost the ability to do that for yourself, then your loved one, whether that's your kid or your niece or your nephew or whoever, will go down to the Court of King's Bench of Alberta, this time an adult guardianship court, and make an application to be appointed as the guardian and or trustee. And you're usually paying a lawyer to assist with that, because in true government fashion, the paperwork for that is quite horrendous. So it's a bit of an undertaking. So I do highly recommend, if you don't already, having an enduring power of attorney and a personal directive, because I always say, at least with a will, if you don't have one, at least there's a piece of legislation that governs what happens to all of your assets if you don't have a will. I mean, you've made it a lot more difficult on the people left behind to navigate that process, but at least there's a piece of legislation that's going to help determine who receives the assets. So, it's not quite as dire as not having the enduring power of attorney and the personal directive from a, paying money practical sense, I guess you could say. So that's what I wanted to say about those 3 documents, and I'm, happy to answer questions on them as well. Which brings me to the final tips and takeaways before I'll open it up to questions and do my best to answer as many as I can. So what is an estate plan? So those 3 documents we talked about: the will, and then the living documents, the enduring power of attorney and personal directive. Why is an estate plan so important? It's to ensure that your estate is administered in the way that you want, and it's to make the transition easier on the people you leave behind, because you'll have clear instructions as to who is supposed to be involved in which tasks, who is going to manage finances, who's going to manage your healthcare, who's going to be the executor, who are the intended beneficiaries, any specific gifts that you want, who's going to step in as a litigation representative if needed. All those things are just taken care of, and so it takes a lot of the burden off of the people who would otherwise be needing to deal with these sorts of things. And then finally and importantly, what is the role of the executor? And so again, this is the person that you would appoint in your will to look after the administration of your estate. The executor, another word for this is trustee. And so what that means is that they are the trustee for every single asset in your estate, and they have the obligation of making sure that they are managing all of those assets appropriately, so that the most possible will end up in the hands of your residual beneficiaries. So it's an important job, as I said before, and it's not necessarily a very easy job. It can be smooth and streamlined, but it can also be very bumpy and very difficult, especially, in my world where I'm dealing with estate litigation and the executors are having to either, bring an action or defend an action on behalf of an estate. It can be very stressful and time consuming. And then also the more, smaller, more practical aspects fall under the role of the executor, so you're applying for any death benefits, you're applying for probate, you're packing up the house, you're, dealing with any small issues that come up, you're turning off the utilities and all those sorts of things. So that's the role of the executor, and why it's so important to put a lot of thought and consideration into who you're going to appoint to do that. Right. So that kind of concludes my brief overview of an estate plan and why it's so important. And I'm happy to open it to questions. Thank you, Heather.
That was really well done. I'm gave me a lot of information. It's a good thing. See, everybody agrees with me. All right. So I do have some questions and I've broken it up into 4 sections.
All
So
right.
let's start with wills.
Okay.
First one was, should you see an accountant for tax planning advice prior to drawing up documents for a will?
This is a great question. What I would say is it depends, which is not a particularly helpful answer at the outset. But if you have a very large estate, I would say absolutely. There's a lot of very interesting and specific tax planning tools. For example, a pipeline deal that is very time sensitive to when somebody passes. So these sorts of things, yes, you would absolutely want to talk to a financial professional. Do not talk to your estate lawyer about it. I always tell people I know just enough to steer you very wrong. So you do want to talk to the proper professional about those things. However, if you have a more standard estate, I would say, taxes are taxes. You got to pay what you got to pay. And I wouldn't worry too much about taxes, especially because there's no inheritance tax. So you don't really need to worry about your beneficiaries in terms of them having to pay any taxes themselves upon receiving the funds, but the estate itself does pay tax. So there is an estate tax. And so that's the one thing that you might want to talk about, especially, like I said, if you have a large estate or if you have properties in multiple jurisdictions. So if you have any property outside of Alberta, especially in Ontario or BC, probably worth talking to an accountant about. Or if you have any international property, again, definitely want to talk to an accountant. So that would kind of be my suggestion there.
All right, we just got a smattering more questions about wills. Hang on
For
a
sure.
sec while I.
I'll do my best. I'll do my best, guys.
Okay, what is the average cost of a will where there are not a lot of assets involved?
Yeah, so I'll give you my standard pricing, and I think it's probably pretty across the board the same. But if you're an individual, so not a couple, because it would be different if you're a couple, but if you're an individual and you're wanting only the will, not the enduring power of attorney and personal directive, then my fee is $750 for a kind of standard basic will. If you're getting all 3 documents, it's $1,000. So that's the will, the power of attorney, the personal directive. And again, that's for an individual with a fairly, for lack of a better description, straightforward estate plan.
Okay. Now, I had to Google this because I had never heard of it before. It says, how effective are hologram wills if you don't have many assets? I had never heard of a hologram will, so you might need to explain that.
Yeah, so it's close. It's actually called a holographic will,
Oh,
which I am going to go out on a limb and assume that's what this person is referring to.
yes.
But a holographic will is one that is completely done in handwriting. So it means that it's not done formally. When you go to a lawyer, you're producing what's called a formal will, and there's very specific requirements in order for that to be done successfully. A holographic will, however, could theoretically, and I've actually been successful in probating, a napkin. So I've had somebody write down their last wishes on a napkin, and I have successfully sent that to probate. So again, my advice is obviously get it done formally. It's the best way to avoid any hiccups.
Yeah.
But you can get a holographic will, probated with success, but it does have to hit certain things in order to be successful. You have to have an executor appointed. You need to successfully give away all of your stuff or make it clear where your stuff is supposed to go. It needs to be signed and dated. So if you do all those things, the holographic will very well could be effective. I'm just always very hesitant to say that it's a good idea that it will be, because if we're being honest, most of the time they're not sufficient. Or you have to go to a lawyer and pay to do what's called a validation application, which I just did a validation application for a client last year because unfortunately their stepfather did not put together a formal will. And all of her siblings who were estranged from the stepfather were trying to sue my client, who was meant to be the sole beneficiary as the only person with a relationship with her stepfather. And we had to go to court, and she had to pay me tens of thousands of dollars to prove that. So we were successful, but you do have to, then pay to do it. Whereas if her stepfather had just gone and, paid for a formal will, all of that would have been avoided.
And what's your stance on those kits, the will kits you can get, like when you're standing there to get
Don't
your
do them.
driver's license renewed?
Don't do them. Holographic will might work. I have yet to see a single will kit ever be successfully done. Not
Really?
once. Not once. And the
All
reason
right.
is because by definition, they are not a holographic will because they're not all in handwriting. And so you have to
Oh,
therefore be a formal will, and people just don't know how to execute a formal will.
okay. That is good to know. If inheritance is a privilege, then assets need not be divided equally. Is this person's understanding correct?
Yes, yet you have no obligation for even hand. In some jurisdictions, you do. A lot of South American countries, for example, I've done a few probates down there, and you actually are obligated to provide certain things to your kids and in certain percentages. But in Alberta, you don't have to give a penny to your kids if you don't want to. You do have obligations specifically to a spouse. That includes an adult interdependent partner, kind of like a common law. Um, and it also, you have obligations to a minor child or an adult child with a physical or mental disability.
Okay. It says that they are in Calgary and they don't have any relatives left. Their best friend is in the US and their assets are under 50,000. Should they have a will?
Yes.
Okay. Is there at any point a limit to where you don't need a will? Or you should just
I
always have a
mean,
will?
I guess maybe I'm a bit biased, but I think you should always have a will. But I also make a living out of going to court and fighting over the issues that arise when you don't, or when you have a poorly drafted one, or where, there might just be a lot of acrimony generally. So I guess I am, coming from it, from a very specific and biased point of view. There's nothing legally requiring you to have a will. I should start with that. You don't have to go out and get one. You don't have any, obligation, positive obligation to do so. But I don't think it's just about how much money you have. I know that's, what we tend to think, and so it doesn't matter. I don't have anything anyway, is what a lot of people will tell me. But like I was saying earlier, it's not just about the money. It's about who's going to deal with it, right? So if you have, $50,000 or $10,000 or whatnot, and you have, a beneficiary, even if it's, not a close living relative, that person now to receive those funds is going to have to deal with it. Um, if there's a creditor, that creditor is going to be hounding that living relative, and all that living relative can do is say, "I'm not the executor. Stop bugging me. Stop hounding me." Um, but if you've ever had any experience dealing with credit chasers, they don't tend to just kindly walk away. So, you're just potentially creating problems by not having a will in place. So that's my personal take on it. But again, you're not under any legal obligation. So, you don't have to do it.
All right. Um, so it says, who does one have to hire to create an EPA and a PD, also a will? So that would basically be yourself, a lawyer.
A lawyer. Yeah,
Yeah.
usually a lawyer does it. I do know sometimes nurses or social workers will try to do at least the personal directive. Um, and with all respect to the very difficult job that our, nurses and healthcare frontline staff are doing, they don't always do the best job. So I would recommend seeing a professional to get those documents executed.
Right. The next one, it says, our only son has developmental disabilities. Should a trustee be the person to handle? Should a trustee be the person to handle the will and estate? Did that make sense to you?
Yeah, absolutely.
Okay.
And you have two options. So you can do what's called a special trustee. So the executor is the trustee, as I mentioned, of your estate, right? And then maybe in your estate, you set up a trust to your son, and you say, I want this trust to be governed by my special trustee, which is a different person than the executor of your will. Or if you don't specify, it would be the exact same person. So it would be the executor who is then managing the funds. But absolutely, I do recommend setting up a trust in that situation. And it's also important when you're considering if somebody does have, a special need or is differently abled, it might be a situation where they're receiving AISH. And so we try to set up very specific types of trust to hopefully not interfere with them receiving their AISH payments.
Okay. How about paralegals for, I guess, setting up those documents? It still needs to go through a lawyer, or is the paralegal able to set up your documents?
Do we know what jurisdiction this person is asking that question from?
We
I'm going to
don't,
guess
so let's
Ontario,
go
maybe.
with Alberta.
In Alberta, we don't technically have paralegals.
Okay.
We have legal assistants, and then we kind of call a more senior legal assistant a paralegal, but it's not technically a different designation. Ontario does have paralegals, and I don't know what the structure is there if you can go to a paralegal and just hire them independently. But in Alberta,
Okay.
you don't hire a legal assistant or a senior, a paralegal independently. It's somebody who works in conjunction with a lawyer.
All right. What happens if the executor does not probate the will?
Well, so okay, so if they don't probate the will, depending on how many assets are in the estate, usually if it's over about 20, 25,000, if they don't probate the will, they're just simply not getting access to the assets. So I would highly recommend they probate it. If it's under $25,000, you might be able to get an indemnity. So the bank will say, okay, if you want access to these funds, you have to promise that if we're giving it to the wrong person, we'll sue you in their place. That's an indemnity.
Okay. I'm going to jump to executors, property, and then interprovincial, and then I'll go back to some of the other questions that have popped up.
For sure.
So what do you recommend if a person does not have an executor of their will? Is there something a lawyer would be able to do? So I think you touched on that one, but can we
Yeah,
just
so
kind
if
of,
you had, let's say, put together a will, but for some reason there was no executor appointed, or the person that you had appointed predeceased you, died before you, then that's what's called a partial intestacy. So it an intestacy, I should back up, means you have no will. So if you die testate, that means you died with a will. If you die intestate, you die without a will. And so the situation you're alluding to there is what we would call a partial intestacy. So you partially testate, partially intestate. And so we'll follow all the instructions in the will, and then we'll apply for what's called a grant of administration with will annexed. So that's the answer to that. But
okay.
it's a fairly complicated procedure.
It sounds complicated. All of this does. Here's a simple question. How many copies of the death certificate should you ask for?
Honestly, they tend to give you a big whack of them, and
Okay.
it's more than you'll ever need, but you tend to receive like almost 10 to 13 seems to be the norm. And oftentimes the funeral home will make that application and get the death certificate um, with you. They'll help you with that process. That's at least been my experience, and they're pretty good at it. So they're a
Okay.
great resource.
Under property, should we put our children's names on our rental property that we have had for 30 years and has appreciated in value?
So this is going to be at least partially dependent on where this person is. I will speak as if they're in Alberta. This is a complicated question. So at law, we have the concept of what's called a resulting trust. And what that means is that the law presumes bargains and not gifts. So if you transfer a property to your spouse, it's presumed to be a gift. But if you transfer a property to your children, it is presumed to be held in trust for your estate. So that means even if you put the kids on title, it is still belonging to the estate unless they can prove it was intended to be a gift to them. So this can be helpful to putting your kids on title. What I would recommend is don't put just one kid on title if you're going to do this. Put anybody who's supposed to be the residual beneficiary onto title. The caveat to that is there could potentially be a tax consequence to doing so, and so you would want to talk to an accountant about that. So the answer is yes, you can do it, and depending on if this is a primary residence, I think you said it was a rental property, so there could be a capital gain tax that you would have to consider if you're going to do that, which you would need to talk to an accountant about. But the short answer is yes, you can do it. But just keep in mind those concepts of resulting trusts and keep in mind potential tax consequences.
Okay, the next one says I own my house and my husband moved in when we were married 14 years ago. I plan to leave my house to my two sons and my husband. Can his children change the will to include them?
I think what this person's probably asking is, can their husband change his will to leave everything to the two kids if she were to predecease him. I'm going to assume that's the intention behind the question anyway, and the answer is yes.
Okay.
So either one, get a prenup, but if it's 14 years ago and you don't have one, I'm going to assume that's too late, which means two, grant him a life estate to the house, which don't grant him the house itself, because if you die before him, he just owns the house. So you want to grant a life estate, which means he has the right to live in the house and to use the house as his own until he dies, at which time it results back, that kind of resulting trust concept again, results back to your estate and then goes through the will to your kids. Now, this is, again, with the caveat of, we do have obligations to our spouses, and he could bring a family maintenance and support claim if he feels that the life estate in that house is insufficient. But there's a whole bunch of factors that go into that, including his need, his age, ability to work, blah, 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 and a whole bunch of different factors. So my suggestion to that, and this is not advice, I need to caveat everything I've said is not advice. These are suggestions based off of me not knowing anything about your individual circumstances. But my suggestion just off the top would be a life estate in a situation like that.
Okay. Let's shuffle over to interprovincial for a moment. So we moved from BC, have our will already, but do we have to do anything now that we are residents of Alberta? So if the will's the same, but you've transferred over, you've moved to Alberta.
Yeah, so like I said, wills are provincially legislated. So you could get a will in Alberta just dealing specifically with your Alberta property. The way I prefer to deal with it is to reference my out of jurisdiction property in my Alberta will. I'm from Alberta. So if I'm drafting a will for a client and they have a BC property, I'll just reference that BC property and say it's my intention that this will governs that piece of property as well. I just find that makes it a little bit cleaner. And then it allows you to reseal the probate, which just means you apply for probate wherever you pass. So if you're resident in Alberta, that's the jurisdiction in terms of applying for probate at the outset. But then you reseal it, just apply again, but a little bit faster in British Columbia. So that's how that works.
Okay.
And then if it's international, instead of being called a reseal, it's just called an ancillary grant. But yeah, I know that's a bit of a roundabout answer, but
No, it
I
makes
like
sense.
the idea of referencing all property in a will, even if it's out of Alberta.
Okay. And if you live in Alberta, but you have beneficiaries in Manitoba, is there anything you have to consider? So if, you know, your kids all live in different provinces, but you pass in Alberta.
I don't think it's, and I should say I don't practice in the province of Manitoba, so I don't really know. But what I would say is I don't think it's much of a concern in Canada. But if you have kids in the States, for example, where their tax system is based on citizenship, but is also subject to an inheritance tax, I would keep in mind that your kid is very likely going to be paying quite a bit of tax. So if that's something that's a concern, you might consider, I don't know, setting up a trust here governed by somebody else, or putting it into a bank account that they have here in Canada. I don't know. It's yeah, it just frankly kind of sucks if your kids in the States are going to be paying a lot of tax.
Those rotten kids moving away. Okay.
Stay in Canada.
Stay in Canada,
especially
kids.
now. You know.
Okay. Okay. So, when should physical assets be disclosed, and how should they be divided if not mentioned in the will? Executor has asked me to sign off on the waiver without providing a comprehensive list of physical assets, and having already dispersed them to all other beneficiaries as well as non-beneficiaries. This is in the chat. I think you should be able to see it because it's a long question.
I'm not sure what this person means by physical assets, if they want to maybe expand on that concept.
Oh, so I think it's saying that sign off on a waiver without providing comprehensive list of physical assets and having already dispersed them.
Like, are they talking about stuff like in the house? Is there a sentimental item this person is concerned that they didn't?
I don't know. I'm going to ask the person to maybe clarify that.
They just said sentimental items.
Oh, okay.
Yeah. So, I mean, if you're concerned that you haven't received a full inventory of the estate yet, definitely don't sign any release. You know, just ask them specifically about the items in question. So I would reach out to the executor and say, you know, thank you for this list, although it you know, isn't including XYZ, and these are important items to me. I'm wondering, you know, what's happened or what's going on, and just kind of get some more information about that, because they do technically have an obligation to provide an inventory. However, I will caveat that by saying that sentimental items kind of aside, um, when, you know, somebody passes, well, technically an executor is, you know, supposed to be dealing with all the assets and doing an inventory. It's not common practice to go through the entire house and list every single item that's in there, you know, the couch and the TV and all that, because quite frankly, none of that's worth anything. You know, furniture doesn't, you know, really hold its value for very long. So usually,
Especially if you're trying to downsize right now.
yeah, right.
Oh
So
boy.
it's very you know, cumbersome. And usually what happens is when you prepare the probate application and the estate inventory, you just put a nominal amount down for household goods of like $1,000 or something like that. But if there's a very specific sentimental item, or if there's a, you know, item that had a lot of value, you know, maybe there was a very expensive painting or something that they owned that, you know, is worth like 15 grand or something, then absolutely you should be following up with those things. And it's the executor's job to note any valuable assets. But I wouldn't, I personally wouldn't, you know, hold an executor's feet to the coals over the value of like a sofa or a TV or something. So it kind of depends on what the thing is.
Okay, good to know. The next one is, so actually this is just a general good question. So this person is talking about an executor in the US, but I mean, if you live in one place and your executor is in a different country, how does that affect the process?
Yeah, it just makes it harder. It's not against the law or anything. You can do it, but the courts don't like it. Um, they'll likely make that executor pay a bond into court. It's a flight risk. Um, but there's nothing illegal. You can do it. It's just not recommended. It just makes it
Okay.
harder.
Okay. Um, is it illegal? Sorry, is it legal in Alberta if you do so the holographic and if you've got two witness signatures on it, that's okay if you're not going to do a like through a lawyer?
And sorry, the question is, it's all handwritten.
Yeah. Is it legal in Alberta if I do a hand printed with two witness signatures? So I guess a handwritten will with two
Yeah, so
witness
I kind of already
signatures.
answered that one earlier.
Yeah.
It can be if you have the information you needed.
Okay. Oh my goodness, I think we just, oh no, there's one more. I thought we
Okay.
got them all. Hang on, one more. I have a vacation home in Eastern Canada, which I plan to leave to my children. Would it be of benefit to add their names to the property, or would it be better just to include that in my will?
So because this is in Eastern Canada, and I always throw out the caveat of I don't practice anywhere other than Alberta, and it is all provincially legislated. I know a little bit about British Columbia just because it's next door, and a little bit about Ontario just because it's so heavily populated. I've run into it quite a bit. I don't know anything about the legislation out in Eastern Canada. So I would recommend talking to a wills and estates lawyer out there about what that looks like from a capital gains perspective and what it looks like from a resulting trust perspective, because I don't know if that concept even exists out in Newfoundland or Nova Scotia or wherever this person might have property.
Okay, I think that's it, and we're just out of time. It's asking where your office is located. Now, you've actually got multiple offices with DD West. I think there's one
Yeah.
in Winnipeg, and where did I see the other ones?
So we have an office in Winnipeg, Manitoba. The office where I'm situated is in Calgary, Alberta. And then we also have a satellite office in Airdrie. So I go out there every once in a while if you know, a client requires it. And then there's also a office, just one
Regina.
lawyer in Regina, Saskatchewan.